Just Stop Oil did not just block roads, its tactics helped trigger a new protest law era. In the beginning, its activists blocked British roads, then they climbed motorway bridges and gantries, then they threw tomato soup at the glass over a Van Gogh painting. Then Parliament changed the law. Britain did not just respond to a protest group, it built a protest law toolkit that now reaches far beyond climate protest. Just Stop Oil ended its street campaign in March 2025. Extinction Rebellion had made a similar tactical shift 2 years earlier under the headline "We Quit." But the powers built during those campaigns did not disappear with them. They stayed in British law, they stayed with the police, and they now apply to every protest movement that comes next. Just Stop Oil claimed victory. Extinction Rebellion framed its move as a reset, not a surrender, but polling during the campaigns told a harder story. Public approval for disruptive climate protest in the UK sat at around 21%. Both groups, in different ways, had read the room. Just Stop Oil began in February 2022 with one demand: stop new fossil fuel licensing. Its tactics were direct. Activists glued themselves to roads, climbed M25 gantries, scaled the Queen Elizabeth II Bridge at Dartford, and threw tomato soup at the glass shield over Van Gogh's sunflower. For supporters, these were emergency tactics in a climate emergency. For critics, they were organised disruption aimed at ordinary people's lives. Morgan Trowland was sentenced to 3 years, Marcus Decker to 2 years and 7 months. At the time, those were the longest prison terms ever handed down in modern Britain for non-violent protest. By 2024, even that would be overtaken. The legal architecture changed in 2 stages. The Police, Crime, Sentencing and Courts Act 2022 created a statutory offence of intentionally or recklessly causing public nuisance, with a maximum sentence of 10 years. After that, prosecutors began bringing the charge against protesters far more regularly. Then, the Public Order Act 2023 went further. It created new offences of locking on, going equipped to lock on, tunnelling, obstructing major transport works, and interfering with key national infrastructure. It extended stop and search to protest contexts, including without individual suspicion, and it created serious disruption prevention orders, civil orders that can restrict a named individual's movements, associations, protest-related activity, and access to particular places. Breaching one is a criminal offence. Then came the quieter move. A statutory instrument tried to lower the threshold again. Serious disruption, ministers said, should mean anything more than minor. Liberty challenged it. The High Court quashed the regulations in May 2024, and the Court of Appeal upheld the core finding on the 2nd of May 2025. Serious, the judges said, cannot mean more than minor. The deeper story was about method. Ministers had used secondary legislation to do what Parliament had already refused to pass through primary legislation. When the British courts pushed back, the fight moved back through the front door. Supporters of the framework say the system held. 2 governments, first Conservative, then Labour, kept the powers because, in their telling, ordinary commuters were being held hostage by a small minority. Ambulances were delayed. Workers lost shifts. Police forces in Britain said protest operations were burning through resources. The Home Office argued that officers needed tools to act before disruption peaked, not after. On this view, the right to protest survived. What ended was the right to use someone else's road, bridge, airport, oil terminal or museum wall as your stage. The critic case is harder to dismiss than the headlines suggest. Roger Hallam, Just Stop Oil's co-founder, was sentenced to 5 years in July 2024 for joining a Zoom call to plan the M25 protest. 4 co-defendants got 4 years each. They were the longest sentences ever handed down in modern Britain for non-violent protest. The UN Special Rapporteur for Environmental Defenders called them a dangerous precedent. The UN High Commissioner for Human Rights criticised them. Amnesty criticised them. So did the former Archbishop of Canterbury, Rowan Williams. Then, in March 2025, the Court of Appeal reduced 6 of the 16 sentences before it. The original 5-year term, Baroness Carr ruled, was manifestly excessive. She said sentencing judges must give weight to conscientious motivation and to Articles 10 and 11 of the European Convention on Human Rights, which protect free expression and assembly. Hallam's sentence was cut to 4 years. 2 co-defendants went to 30 months. 10 other appeals were dismissed. The wider numbers are blunt. According to data from the Metropolitan Police, more than 2,200 climate protesters were arrested in London between 2022 and mid-2025, and roughly 3/4 were charged. Over the same period, around 300 far-right protesters were arrested, and less than 1/4 were charged. University of Bristol research found that climate protests in the UK led to arrests at roughly 3 times the global average rate. So the system map is simple. Parliament writes the offences. The Home Secretary brings operational rules into force, sometimes by statutory instrument. Police commanders decide which powers to use against whom and where. Who benefits? The state benefits because disruption falls. Infrastructure operators, motorways, airports, oil terminals and transport networks, get clearer legal protection. Governments benefit from being seen to act. Who pays? Activists go to prison, sometimes for years, for offences that did not exist in this form a decade ago. Some come out under licence conditions that restrict further protest. Lucia Whitaker Diabreu, released in April 2025 after her sentence was reduced, was barred from attending climate protests or contacting activist groups. And the effect reaches beyond climate. Trade unions, Palestine marches, anti-war demonstrators all now face the same statutory toolkit. The toolkit is still expanding. The Crime and Policing Act 2026 received royal assent on the 29th of April. After the courts rejected the secondary legislation route, the British government returned to primary legislation, adding new protest powers, including offences for concealing identity at certain protests and provisions for police, to consider the cumulative impact of repeated demonstrations in an area. The street campaigns ended. The legal apparatus built around them did not. The argument was never really about soup on a painting. It was about how much disruption a democracy is willing to absorb to hear an unpopular case, and what kind of country is left when the answer is less.